I said, I want to speak specifically about this new Ontario regulation. It's called the Ontario Infectious Disease Emergency Leave Regulation. Now, this new regulation, again, under the Employment Standards Act in Ontario, has temporarily changed the rules related to layoffs and constructive dismissal in Ontario, and it deems certain employees to be on the recently enacted infectious disease emergency leave. Now, this only impacts provincially regulated employers in Ontario right now. I want to be clear there. So those in other provinces or who are federally regulated are not impacted at this point, but it is important for you all to understand this because provincial governments do often follow each other's lead in passing these types of laws that are related to issues that are relevant nationwide. And of course, this is one of those. Now, these temporary changes apply to employees who experience reductions in hours or wages, retroactive to March 1st of this year, and going forward into the future until 6 weeks after Ontario's current declaration of emergency ends. Now, we don't know right now when that declaration of emergency will end, but the province did confirm this week that the emergency would continue at least until the end of June. And so with that news, employers can expect that the temporary changes under this new regulation will continue until 6 weeks later, until at least mid-August, if not later if the declaration of emergency is extended again, as it has been a number of times. Now, the regulation confirms that temporary reductions to employees' hours of work or wages during the period in question do not constitute a layoff under the Employment Standards Act. That's a clear change to the regular rules under the ESA. That means that the Employment Standards Act layoff rules, including the maximum durations of layoffs under the ESA, will not apply to these employees who have been temporarily put off work or whose wages or hours have been reduced temporarily since March 1st. Now, as I noted a moment ago, in addition to deeming that those employees are now considered to be on no longer considered to be on layoffs, the regulation also deems those employees to be on the infectious disease emergency leave under the Employment Standards Act, and that's the relatively new leave that Ontario enacted in response to COVID-19. Now, as many employers will know, generally, when an employer is on a statutory leave under the Employment Standards Act or other employment standards legislation across the country, they have certain important protections. Those include generally that their job is protected while they're on their leave, and in Ontario that their benefit plans, including health, dental, disability, pension benefits, and others, have to be continued by the employer during the employee's leave. But although those are the regular important rules when it comes to statutory leaves under the ESA, there are some important exceptions in this new regulation that deems employees to be on this leave. Those include, first of all, that if employees were laid off at some point before May 29th, and their benefits were not continued during the layoff, and they're not generally required under the ESA to be continued during a layoff, then the employer will not be required to reinstate the employee's benefits at this point and then for the rest of the period that they're off work, despite that the employee is now considered to be on leave, and if they were on a leave from the beginning, the benefits would have had to be continued. Now, with that said, employers that previously laid employees off but were continuing the employee's benefits as of May 29th, for example, the many employers that did so in order to take advantage of the longer layoff duration that's permitted under the ESA when benefits are continued in normal times, the employers in those cases where those benefits are still active on May 29th are now required to continue them for the rest of what's now considered a leave. Now, the other big exception that's more important for many employers is that if an employer decides to permanently terminate the employment of one of those employees who's been off work on what was previously considered a layoff and is now a leave, or whose wages or hours have been reduced, the employee is no longer deemed to be on leave when that termination happens. What that means effectively is that these deemed leaves right now aren't really job protected leaves, because again, the employee is not on a leave if they're let go, and therefore they can be let go without violating the terms of the leave. That's going to give employers a lot more flexibility in deciding whether or not to bring these employees back to work as compared to other employees who are on statutory leaves. Now, another key point in this regulation is that it also deems those temporary reductions to employees' hours of work and wages that I spoke about to not constitute constructive dismissal during this temporary period. As we discussed in part 1 of this seminar, layoffs generally constitute constructive dismissal at common law unless the employment contract contains a clause that permits layoffs. And that's the case even where the provincial employment standards legislation permits the layoff under its terms. Now, I also spoke last week about the speculation among employment lawyers about whether that general rule will be changed because so many employers had no choice but to temporarily lay their employees off when COVID-19 hit. And I also discussed our expectation that there will be a lot of litigation started in the coming months by employees claiming that temporary layoffs or reductions in wages or hours of work that happened in the first few months of the pandemic amounted to constructive dismissal at common law. Now, it's important to note that employees can be considered to be constructively dismissed both under the Employment Standards Act for the purposes of the statute specifically, and under the common law. And it remains unclear at this point whether this new regulation is intended to change that general common law rule that layoffs typically amount to constructive dismissal, or whether it's only intended to mean that they're not considered constructive dismissal for the purposes of the statute without impacting that general common law rule that layoffs are constructive dismissal at common law unless the employer has the contractual right to lay the employee off. We're already seeing interpretations right now by lawyers for employees that this regulation should not impact that common law rule that layoffs are constructive dismissal and should be limited to the ESA only. While employers, on the other hand, will want to argue that this regulation changes that common law rule about layoffs and constructive dismissal, and therefore means that temporary layoffs in this context during COVID-19 are no longer going to be considered constructive dismissal for the purposes of the common law. Now, there are at least reasonable arguments both ways. And so at this point, unless the government clarifies what it intended by the constructive dismissal provisions of this new regulation, we're going to have to wait until the courts rule in all those litigation, all those cases that I mentioned a moment ago, whether this new regulation changes that common law rule as well as the statutory rules or just the statutory rules themselves. So with that, we still expect to see a lot more litigation in the coming months. This regulation at this point is not expected to change that. It just may potentially change the outcome of that litigation. Now, another really important point to note is just since this regulation was released fairly quietly on Friday, in just those few days, many different workers' advocacy groups, including the Ontario Federation of Labour, have been creating significant pushback on the regulation. And I've also spoken here about how the most significant aspects of this new regulation, and so I know many Ontario-based employers will have their work cut out for them in assessing what this regulation means for them. And I don't mean to add to that work for Ontario employers, but I'd be remiss not to note here that given the uncertainty about the scope of the constructive dismissal portion of this regulation, as well as the significant lobbying that we'll be seeing from workers' advocacy groups of the government, it's still possible this regulation could be amended. And so employers that have employees laid off right now or have reduced their wages, and again, where those employees are now currently considered to be on leave, should stay tuned to see if there are any other developments to make sure that they're still complying with the law as it keeps changing so quickly.